Begin with the court ruling against the argument the president is using to stonewall the impeachment investigation. A federal court judge has rejected the White House claim of absolute immunity, ruling that former White House counsel Don McGahn must testify in the impeachment inquiry. The House Judiciary Committee subpoenaed McGahn earlier this year for testimony on possible obstruction of justice in the Mueller investigation. When the White House blocked his appearance, the committee sued, and yesterday a federal judge sided with Congress, writing in her opinion this, quote, stated simply, the primary takeaway from the past 250 years of recorded American history is that presidents are not kings. This means that they do not have subjects bound by loyalty or blood whose destiny they are entitled to control. That a ruling by Judge Jackson in a federal court. An official tells NBC News the Justice Department will seek a stay to stop the ruling from taking effect immediately. The White House in a statement said this decision contradicts long-standing legal precedent established by administrations of both political parties. We will appeal and are confident that the important constitutional principle advanced by the administration will be vindicated. While the ruling only compels McGahn's testimony, the Trump administration also has used the now rejected absolute immunity claim to defy congressional subpoenas for Vice President Pence, Secretary of State Mike Pompeo, and Acting Chief of Staff Mick Mulvaney. Former National Security Advisor John Bolton has not been subpoenaed, but people familiar with his views are now telling the Washington Post he would testify if cleared by a federal court. Danny, let me start with you just on the nuts and bolts of this, what it means exactly. So what Judge Jackson effectively said is Don McGahn has to go testify before the House Judiciary Committee, forget the immunity claim. But once he's in the chair, he can still claim executive privilege. Do I have that right?
That's right, on a case-by-case or even question-by-question basis. What this ruling holds, and it is a significant opinion, but it's not a surprise, because the same court decided essentially the exact same issue back in 2007. That case, involving Harriet Miers at the time, did not make it all the way to the end of appeals. It was resolved otherwise. But there's nothing about this opinion that is really that shocking, because everything that the court holds or that compels the testimony or shoots down the absolute privilege argument, or immunity rather, is based on case law. The administration's position is instead based on their own internal OLC legal opinions, which have no binding legal precedent at all. In a sense, the winner in this case was never going to be in doubt. And if it goes up on appeal, the result will probably be the same. The net takeaway is that there is no absolute immunity for executive officials, high-ranking executive aides. Instead, they have to show up, they have to comply, then they may have individualized executive privilege claims. But you can't ignore a congressional subpoena. That's the big takeaway today.
Let's also bring into the conversation, Mike, White House correspondent for PBS NewsHour, Yamiche Alcindor, and NBC News correspondent covering national security and intelligence, Ken Dilanian. Mike, so we should point out this, we're talking about Don McGahn here because we've sort of had so many names come through in the last several months. Don McGahn was the former White House counsel who left last fall. We're talking here about the Mueller investigation, which in this case is separate from the Ukrainian investigation, but there may be some implications for the Ukrainian investigation if it sets a precedent that allows someone like John Bolton to go testify.
No, clearly, but in this sea of subpoenas, Danny, that have been issued, many people who have been issued a subpoena have just totally ignored the subpoena. How does that happen? If I get a subpoena, if Eddie gets a subpoena, we have to respond to it.
That's right. They're playing a game of chicken because Congress has this broad power to subpoena. But what we're finding out in the last couple of years is that they don't really have a very good enforcement mechanism, so that someone who receives a congressional subpoena, if they have the chutzpah, if they have the courage, can oppose it. And if they drag it out long enough, the amazing thing is, once you get a new Congress in, that subpoena kind of disappears into the ether. And that's exactly what the administration and others associated with it are doing. They're saying, well, if I run out the clock as long as I can, then the need for this subpoena may dissipate. In fact, that's what happened with the Harriet Miers case back in 2007. It never made it all the way through to appeals. It was resolved in another way. And then you had this freestanding court opinion for over a decade that really left us wondering where exactly the law is on this issue.
So in the Mueller report, Ken Delaney, we know that Don McGahn testified for about 30 hours in front of the special counsel's office. We know that he testified that President Trump asked him to fire Robert Mueller at one point in 2017. How significant is this ruling to that case?
Well, look, I don't actually think that this ruling is going to affect how Congress deals with airing that matter before the public, because it's going to be appealed, it's going to drag out, and look, they're going to take a vote here, before Thanksgiving on the Ukraine matter. They're moving ahead. So Congressman Schiff keeps using this term rope-a-dope. He says, I'm not going to be dragged into a long court fight hoping that we get the testimony of these people. Nonetheless, because of what Danny said, this is a hugely important decision that will last potentially long after the Trump administration is gone, because since 1971, the executive branch has claimed this right of testimonial immunity, saying that Congress has no right to call close presidential aides to testify. And what this judge said was that doesn't exist. That is not a thing. And so, as you said, McGahn will, of course, even if once this is appealed and goes all the way through, and assuming that this ruling holds, McGahn will then claim executive privilege on these because he was advising the president about how to respond and how to deal with the Mueller investigation in his capacity as White House counsel. And executive privilege arguably does protect some sensitive conversations with the president. So we may never see McGahn's testimony, but nonetheless, this is an incredibly important ruling, because especially in light of the recent speech that the Attorney General made, arguing essentially for unchecked presidential power, and that these many investigations by Congress amount to harassment. Now, that's a sort of a distorted view of an argument that the executive branch has been making for a long time, and what this judge said is absolutely not. Congressional investigations are enshrined in the Constitution, and they have a right to call aides to come and comply with subpoenas.
Yeah, that's what it's a separation of powers argument,
Exactly.
is what Judge Jackson made yesterday in court, Eddie.
Yeah, I just wanted to underline what Ken just said, because oftentimes we confuse two things, right? There's the bad actor that is Donald Trump. And then there are the arguments surrounding Donald Trump around a unitary executive, about an imperial presidency. And it seems to me that there's some folks like Bill Barr who's actually defending this rather radical understanding of the executive power. And then there are folks who are defending Trump. And then there's the way in which those two things converge. What we saw yesterday is a kind of a clear distinction. Judge Jackson invoked Federalist 51. Right, which was all about the separation of powers, right? So we have, in some ways, a clear enunciation that this idea of unlimited executive power is just simply unconstitutional. It just has no merit. So that argument now is in full view, as opposed to just simply being something driving behind the scenes the way in which people have been defending Donald Trump.
Yeah, the headline from Judge Jackson yesterday, again, Richard, was "Presidents are not kings." That's the case she was making yesterday.
Well, no, it really was classic Federalist paper. This is a public civics classroom. I had a question for the lawyer types around the table. So just say people ultimately testify. Who gets to decide whether executive privilege is claimed? If John Bolton testifies, does he assert it? Can the White House instruct him to assert executive privilege? Does he have the discretionary right to say, actually, I choose to answer this question? How does that play out?
They can instruct him, and then it would probably go, again, immediately to the courts. And that creates a real problem. Now, obviously, an individual can say, I'm not going to comply with that order. That, again, would go to the courts at every turn. And this is why these legal issues have been left so unresolved for so long, is that in many cases, Congress says, well, you know, what's the point of the battle? Let's try to negotiate something else so that we get something today as opposed to maybe something in the future. And just one other thing to build on what Eddie said is that it's so interesting that the administration argued separation of powers means that we as the executive are untouchable. And the court said, no, you've got it exactly wrong. It's the opposite. Separation of powers means that the different branches act as a check on each other. And it is exactly our job as the judiciary to check you, the executive branch.
Yeah, Yamiche, as I pointed out, Don McGahn testified to Robert Mueller that President Trump asked him to go fire Robert Mueller, fire the special counsel, and he refused to do so. President Trump has denied that in interviews since then, of course. What is the White House reaction to this? Do they show any concern about this, or do they think this is just another step along this path of impeachment that Democrats are trying to pursue?
The White House is obviously concerned about this. Don McGahn is someone who was at the center of the White House and understood what was going on with the president, understood some of the orders that he was giving. But I think what's even more interesting or more concerning than Don McGahn's testimony, since Democrats really do want to focus so narrowly on this Ukraine issue, is what that will mean for the people that have been named by all the witnesses that came forward in these impeachment inquiry hearings. There were so many names listed. There was Secretary Pompeo, Vice President Pence, Acting Chief of Staff Mick Mulvaney, Energy Secretary Rick Perry, all of these people that are not testifying as people under them, like Alexander Vindman, Lieutenant Colonel Al Vindman. He's someone who's working at the White House and decided to show up. But there are these higher up officials who are very close to President Trump, who understand what the president's thinking, who don't want to come to Congress. So I think the White House are not, those people might then somehow be compelled to be part of this impeachment inquiry.
So, Ken, let's talk about potential implications for the Ukraine conversation. This, again, we're talking about testimony for Don McGahn before the House Judiciary Committee. But what about for the House Intel Committee and a witness like John Bolton, someone who's been sort of flirting with the idea of speaking publicly in one form or another, whether that's a book or testimony in the impeachment inquiry remains to be seen. Does this set some kind of a precedent in that conversation?
Well, it certainly does. To Yamish's point, it absolutely does. The judge even mentioned that national security does not create testimonial immunity either. However, it would allow Bolton to claim executive privilege. But you can argue that a lot of what's covered in this Ukraine matter does not really implicate U.S. national security. You know, Democrats would say it's a criminal scheme. And in the famous Nixon Supreme Court case, you know, Nixon had to give up the tapes because the judge ruled that, you know, executive privilege doesn't trump a valid criminal investigation. And so that has got to be a concern for the White House here. John Bolton, Mick Mulvaney, Mike Pompeo, all these people who have resisted congressional efforts to get them to talk about Ukraine. Now, that said, there's a long road of litigation here, and Democrats are on a much different timetable. So realistically, you know, will the courts decide this on the timetable that Democrats need to get an impeachment vote and to get this information before the public? That seems unlikely, but it may affect, you know, future generations. This could be a really important precedent that is being now set by this ruling.
So, Danny, as Ken points out, there's sort of the legal timeline, appeals, stays, all the rest of it, and then the political timeline. Adam Schiff signaled again yesterday to his members, we want to get this moving. When it gets something done, get a vote sometime before Christmas. So just as a practical matter, how long could this play out? This McGahn question only. We have a stay right now. How long could this go on?
We're only at the district court, which is the lowest trial court. And from there, they're going to appeal right to the D.C. Circuit and from there to the Supreme Court. They're at the very beginning of this road. So it could take a very long time. Now, of course, in important issues like this, they will often expedite matters at appeal, but they still need to brief the issues. And the court, look at this. We just had a over 100-page opinion just issued by the district court. And these kinds of things take time. So that's why Congress knows that discretion may be the better part of valor. Get what they can today immediately through negotiation and only press forward if the other side refuses and stonewalls completely. That's how we get existing case law and future precedent.
In other words, this will not be tied up, the McGahn issue, before Christmas when Adam Schiff wants a vote on impeachment.
Oh, it'll be tied up, but not in the way you're saying. It'll be tied up in the courts.
All right. Danny Cevallos, thanks so much as always. Ken Dilanian, you'll be back with us next hour when we talk with the co-founders of Fusion GPS about their new book, Crime in Progress, Inside the Steele Dossier and the Fusion GPS investigation of Donald Trump. We'll see you in a bit, Ken.
Thanks for checking out MSNBC on YouTube, and make sure you subscribe to stay up to date on the day's biggest stories. And you can click on any of the videos around us to watch more from Morning Joe and MSNBC. Thanks so much for watching.